You own a bond, its history. Part 4. What happened in 1776? Whoever owns the soil, owns all the way to the heavens and to the depths of the earth. Old Latin maxim and Roman expression. 1776 is the year that will truly live in infamy for all Americans. It is the year that the Crown Colonies became legal Crown states. The Declaration of Independence was a legal, not lawful, document. It was signed on both sides by representatives of the Crown Temple. Legally, it announced the status quo of the Crown Colonies to that of the new legal name called states, as direct possessive estates of the Crown. See the definitions above to understand the legal trickery that was done. The American people were hoodwinked into thinking they were declaring lawful independence from the Crown. Proof that the colonies are still in Crown possession is the use of the word state to signify legal estate of possession. Had this been a document of and by the people, both the Declaration of Independence and the U.S. Constitution would have been written using the word states. By the use of state, the significance of the government of the state possession was legally established. All of the North American states are Crown Templar possessions through their legal document, signed by the representation of both parties to the contract, known as the Constitution of the United States of America. All constitutional rights in America are simply those dictated by the Crown Temple and enforced by the Middle Templars, Borough through their franchise and corporate government entity, the Federal United States Government. When a state citizen attempts to invoke his constitutional, natural, or common law rights in chancery, equity courts, he is told they don't apply. Why? Simply because a state citizen has no rights outside of the rule and codes of Crown law. Only a state citizen has natural and common law rights by the paramount authority of God's law. The people who comprise the citizenry of the state are recognized only within natural and common law, as is already established by God's law. Only a state citizen can be a party to an action within a state court. A common state citizen cannot be recognized in that court, because he doesn't legally exist in Crown Chancery courts. In order to be recognized in their state courts, the common man must be converted to that of the corporate or legal entity, a legal fiction. Now you know why they create such an entity using all capital letters within birth certificates issued by the state. They convert the common lawful man of God into a fictional legal entity subject to administration by state rules, orders and codes. There is no law within any rule or code. Of course, rules, codes, etc. do not apply to the lawful common man of the Lord of Lords, so the man with inherent godly law and rights must be converted into a legal person of fictional status, another legal term, in order for their legal, but completely unlawful, state judiciary, chancery courts, to have authority over him. Chancery courts are tribunal courts where the decisions of justice are decided by 3 judges. This is a direct result of the Crown Temple having invoked their rule and code over all judicial courts. It is held to be a settled rule that our courts cannot take notice of any title to land not derived from the state or colonial government, and duly verified by patent. 4 Johns. Representative 163. Jackson v. Waters, 12 Johns. Representative 365. S.P. The Crown Temple was granted letters patent, see definition above, and charters, definition below, for all the land, colonies, of New England, by the King of England, a sworn member of the Middle Temple, as the Queen is now. Since the people were giving the patent/charter corporations and colonial governors such a hard time, especially concerning Crown taxation, a scheme was devised to allow the Americans to believe they were being granted independence. Remember, the Crown Templars represented both parties to the 1776 Declaration of Independence, and, as we are about to see, the latter 1787 U.S. Constitution. To have this declaration recognized by international treaty law, and in order to establish the new legal crown entity of the incorporated United States, Middle Templar King George III agreed to the Treaty of Paris on September 3, 1783, between the Crown of Great Britain and the said United States. The Crown of Great Britain legally was, then and now, the Crown Temple. This formally gave international recognition to the corporate United States, the new Crown Temple states, colonies. Most important is to know who the actual signatories to the Treaty of Paris were. Take particular note to the abbreviation Esquire following their names. See above definition for Esquire, as this legally signifies officers of the King's Courts, which we now know were Templar Courts or Crown Courts. This is the same Crown Templar title given to Alexander Hamilton, see above. The Crown was represented in signature by David Hartley, Esquire, a Middle Templar of the King's Court. Representing the United States, a Crown franchise, by signature was John Adams, Esq., Benjamin Franklin, Esquire, and John J., Esquire. The signatories for the United States were also Middle Templars of the King's Court through Bar Association membership. What is plainly written in history proves, once again, that the Crown Temple was representing both parties to the agreement. What a perfect and elaborate scam the people of North America had pulled on them. It becomes even more obvious when you read Article 5, which states in part, to provide for the restitution of all estates, rights, and properties which have been confiscated, belonging to real British subjects. The Crown Colonies were granted to persons and corporations of the Crown Temple through letters patent and charters, and the North American colonial land was owned by the Crown. Now, here's a real catch-all in Article 4. It is agreed that creditors on either side shall meet with no lawful impediment to the recovery of the full value in sterling money of all bona fide debts heretofore contracted. Since the Crown and its Templars represented both the United States as the debtors and the Crown as the creditors, then they became the creditor of the American people by owning all debts of the former colonies, now called the legal Crown States. This sounds too good to be true, but these are the facts. The words scam and hoodwinked can't begin to describe what had taken place. So then, what debts were owed to the Crown Temple and their banks as of 183? In the contract between the King and the 13 United States of North America, please view this webpage, http://avalon.law.eth/178.fr-172.asp. Signed at Versailles, July 16, 1782, Article I states, it is agreed and certified that the sums advanced by His Majesty to the Congress of the United States under the title of a loan, in the years 1778, 1779, 1780, 1781, and the present 1782, amount to the sum of 18 million of livres, money of France, according to the following 21 receipts of the above-mentioned underwritten Minister of Congress, given in virtue of his full powers, to wit, that amount equals about $18 million plus interest, that Hamilton's U.S. Central Bank owed the Crown through Crown Bank loans in France. This was signed, on behalf of the United States, by an already familiar Middle Templar, Benjamin Franklin, Esquire. An additional $6 million, 6 million livres, was loaned to the United States at 5% interest by the same parties in a similar contract signed on February 25, 1783. The crown bankers in the Netherlands and France were calling in their debts for payment by future generations of Americans.